Now, this morning, I get up very early. This morning, I took a look at a piece on Twitchy, which is a great site, and the Business Insider, which is leftist, but nonetheless, I believe it is. Maybe I'm wrong, whatever it is. And there was a piece there. And it talked about a lawyer in the federal courthouse on Monday in front of Judge Kimba Woods, the love judge. And this lawyer was representing CNN and the New York Times. And apparently after the wrangling took place between the government and Michael Cohen's lawyers on attorney-client privilege and whether he's required to reveal the names of a client, the judge seemed to be going in the right direction. But then suddenly this lawyer for CNN and the New York Times jumps up. And this lawyer says, wait a minute, we're in the press and we have the right to know. CNN and the New York Times and the media have the right to know who this other quote-unquote client is. There they are in open court in front of the public, in front of the cameras, or not cameras, in front of the media. And she directs Cohen's lawyer to state it in public. And that just demonstrates the love judge isn't a particularly smart judge. You'll see all the liberal media out there saying she's absolutely brilliant. Oh, my God, she's the smartest judge of judges. No, she's not. In fact, she appears to be quite dim-witted, if you ask me. This is not a hard area of the law. This is not a hard area of the law. And there's an outstanding piece, as usual, by Andy McCarthy over there at National Review Online. And he's a former federal prosecutor for 20 years in the Southern District of New York. And he writes, the outrageous outing of Sean Hannity. It violated long-standing judicially endorsed standards. And remember who was behind this, CNN and the New York Times. He said, I've contended that it was outrageous for Federal District Judge Kimba Wood to direct that talk radio and Fox News host Sean Hannity be publicly identified as Michael Cohen's third client, Cohen, whose law practice is, he writes, shall we say, less than thriving. It's under criminal investigation by the FBI and federal prosecutors in the Southern District. He claims only 3 clients. The other 2, President Trump and GOP fundraiser Elliot Brody, acknowledge retaining Cohen. Hannity denies ever having had a formal attorney-client relationship with him. The court's order that Hannity, that his name be disclosed in open court, violated long-standing, judicially endorsed standards against identifying uncharged persons in legal proceedings attended to criminal investigations. Let me repeat that, so even the thoroughly dim-witted pretend lawyer by the name of Joe Scarborough can hear what I just said. And all the other clowns out there. The court's order that Hannity's name be disclosed in open court violated long-standing, judicially endorsed standards against identifying uncharged persons in legal proceedings attended to criminal investigation. And this also goes for the genius down the street from me. Hey, I was a lawyer. Okay, good for you. He says, forget about evidence of wrongdoing. There's not even a suggestion that Hannity's involved in any crimes. He's a longtime friend of Cohen's. He says they've had some informal legal discussions about such matters as real estate. And as any lawyer will tell you, informal discussions with non-lawyer friends are common. Hannity insists that he has never retained Cohen to represent him in any legal matter and has never paid him or received an invoice from him. There's no public evidence to contradict this and no suggestion that Cohen has previously represented himself as Hannity's attorney. There's been no intimation that Hannity has any pertinent information about the activities for which Cohen is under investigation. His only relevance to the probe involves the question of whether there is a factual basis for Cohen to claim attorney-client relationship with Hannity, whether that should prevent investigators from pursuing some materials seized by the FBI from Cohen's residences and office. And since Hannity is not suspected of wrongdoing, even that question appears to be of little importance. So there was no reason for Hannity's name to be revealed publicly. Grand jury proceedings are secret by law. When prosecutors and agents conducting an investigation seek judicial warrants to search, eavesdrop on, or arrest subjects, it's done ex parte and in camera, not in public hearings. In short, the public does not have a right to know the names of people, whether or not suspected of wrongdoing, who pop up in a criminal investigation. And ladies and gentlemen, these rules are in place to protect you. Not Hannity, not me, to protect you, the common man, the common woman. So you can go to a lawyer with confidence, knowing that when you have a discussion with a lawyer, it's protected. And prosecutors are not free just to start throwing your names in pleadings, in motions, throw them in front of a judge to embarrass you, humiliate you, and ruin you, and even threaten you. Monday's hearing was public. Whether it needed to be is debatable, he writes. The matter is under grand jury investigation, and it involves search warrants. Neither of those things entails public proceedings. Yet the issue for the court's consideration, he's saying, in other words, this isn't an open federal court. This isn't a grand jury. Why was this piece public? Yet the issue for the court's consideration was Cohen's motion to bar the government from reviewing the material seized, which he filed publicly. It would probably have been better if Judge Wood had held the hearing under seal. She could later have issued a public decision that explained her ruling on the legal question without disclosing client names or any other factual information related to the investigation that may have arisen. No, you don't understand, Andy McCarthy. She's brilliant. The Love Judge is the smartest judge we've ever seen before. Instead, the judge elected to proceed publicly. But she still should have limited the open court discussion to argument about the legal issue, retreating in camera, meaning in her office, for any discussion of client names. In any event, the prosecutors could easily have handed Cohen's attorney, Stephen Ryan, a grand jury subpoena demanding disclosure of the client identities. In other words, keep it secret, called 6E information in front of the grand jury. This was not necessary in open court. Now, that would have required Cohen's lawyer, Ryan, to reveal the identities to the grand jury, but not the public. Clearly, the prosecutors and Ryan were aware of this. As the Atlantic's Natasha Bertrand tweeted yesterday, Ryan was prepared to surrender the information to the government under seal. That's Cohen's lawyer. But Judge Wood was initially disposed to let that happen. Then, however, the judge allowed Robert Balin, an attorney for CNN and the New York Times, to intervene. Balin, the Times reports, argued that potential embarrassment was not a sufficient reason to withhold the purported client's name from the public. And the judge was somehow persuaded by this frivolous contention. And without providing Hannity any notice, an opportunity to be heard on the matter, she directed that his name be disclosed in open court. The flaw in Balin's argument is patent. It is true that if the public has a legal right to know a piece of information, the fact the information is likely to embarrass someone is not sufficient cause to suppress it. But the public has no right to know the names of people who are relevant to an investigation, even if they're suspected of wrongdoing, and Hannity is not. That's why names do not appear in so many of these documents. Instead, it's number 1, unindicted co-conspirator, Corporation X, cooperating witness, things of that sort. I'll wrap this up when I return. We all wanted to believe companies would clean up their acts, right? But they haven't. It's only gotten worse. Every week we're hearing about another breach. Now it's Panera Bread and Delta Airlines and the Facebook situation. First it was 50 million people. Now it's 87 million. I wonder how many other breaches there are that we don't even know about yet. You can't wait around to see what happens. You can't rely on other people. You have to protect yourself, just like I did. And I found the number 1 best company to take care of me and my family, My ID Care. They used to only represent, and help major corporations. But now they're willing to help people like us. And that's why I chose them. And that's why I want to strongly encourage you to do the same thing. For less than $10 a month, My ID Care covers you for the 9 types of identity theft, and they provide a 100% identity recovery guarantee if you do fall victim, or your money back. Now, you can't find this level of protection anywhere else. Learn more and get 15% off at myidcare.com with promo code MARK, or call 866-334-3084. That's 866-334-3084. myidcare.com, promo code MARK, or 866-334-3084. What's the bottom line here? The bottom line is the protection of Hannity's name or your name in a case like this actually has nothing to do with attorney-client privilege. The public has no right to know the names of people who are relevant to an investigation, even if they are suspected of wrongdoing, which Hannity is not. Even when the government arrests somebody, as McCarthy writes, even if they arrest someone or formally accuse someone of a crime in an indictment, the names of uncharged persons are not disclosed. So that's the rule in every United States Attorney's office in the nation, 93 of them. That's the rule at Main Justice in Washington, D.C. That's the rule in every federal courthouse in America, except in front of the love judge, Kimba Woods. She directed Mr. Cohen's lawyer in open court to reveal Sean Hannity's name at the request of CNN's lawyer, a lawyer also for the New York Times. And CNN ran with this day in, hour out, and they never revealed that it is they, CNN and the New York Times, that went into court to drag Hannity's name through the dirt.
You've been...
Hello, everybody. Mark Levin here. Our number, 877-381-3811, 877-381-3811. I want to go through this again. This is very important. CNN and the New York Times sent their lawyer into this federal courthouse in front of a left-wing judge who's not particularly bright, as it turns out, Kimba Woods, the love judge. The government is saying, no, attorney-client privilege, he's not really an attorney, so, we get to keep everything. And then they argue in the alternative. And besides, we can create this, what's called a Chinese wall, and we can have FBI agents and investigators look at this stuff, or untainted, untaint unit, to look at this stuff who aren't actually involved in the case. Michael Cohen's lawyer says, no, we need a special master. This should go to a third party, somebody we respect, who looks it all over. And then the judge says, okay, well, I'm going to decide for the government right now, because, of course, we can trust the prosecutors in the Southern District. They're outstanding. That's what she says. So many words. Then there's this nebbish lawyer saying, wait a minute. I represent CNN and the New York Times. We want to know who that other client is. The public has a right to know. The public has a right to know. So the moron judge thinks about it and says, yeah, you're right. I order you to disclose the name of your other client, Sean Hannity. In the audience, whoa, my God, Hannity. Dershowitz goes on Hannity's show. Sean, you should have revealed that. Should have revealed that, Sean. What's the other guy? Owen Williams. Yeah, Sean should have revealed that. It's obvious conflict. That's just Fox. Then there's the CNN. You have Colbert, who's a moron. Kimmel, who's a moron. They don't understand any of the issues. Doesn't matter. And Andy McCarthy says, this is all BS. That, in fact, the court and the government should have protected his name, as they do everybody else in every federal courthouse where U.S. attorneys are involved. And the judge knew it, and the U.S. Attorney's Office knew it. So that tells you what kind of court we have here and what kind of lawyers we have involved in this case. And McCarthy writes in his piece in National Review, though they apparently chose, that is the government lawyers, not to remind Judge Wood of the long-standing policy to keep the names of people like this out of public view. Because, you see, here's the reason. You can have the government filing all kinds of papers, naming all kinds of people. Next thing you know, they hurt their reputations. They hurt their business responsibilities, their employment responsibilities, or they create a spectacle like exactly what they did. Exactly what they did in Hannity's case. So the United States Attorney's Manual, the manual, admonishes that, quote, in all public filings and proceedings, federal prosecutors should remain sensitive to the privacy and reputation interests of uncharged third parties. So unless a person has been formally charged with a crime, not only should the government avoid publicly naming the person, federal prosecutors are further schooled to avoid even an unnecessarily specific description that might reveal them. In other words, while calling Hannity client number 3 would have been proper, even referring to him as an example as SH would have transgressed the policy. There is no justification, none, for publicizing his full name. The U.S. Attorney Manual elaborates. Federal courts have held that there is ordinarily no, quote, no legitimate government interest served by publicly naming an uncharged person. Now that's the case, even when charges against the person are being contemplated. A fortiori, there's no excuse for gratuitously embarrassing someone who's suspected of no wrongdoing. The investigation of Cohen involves the suppression of information about extramarital affairs and so forth and so on. Hannity has nothing to do with that. Nothing to do with payments. And then McCarthy ends his piece by saying, under this kind of justice, courts protect uncharged people from being identified in public proceedings in connection with criminal investigations. The failure of the court and the government lawyers to enforce that standard just adds fuel to the fiery contention that where President Trump is involved, investigations are driven by politics, not law enforcement. There was no justification whatsoever, legal or ethical, for this federal judge, the love judge, Kimball Woods, directing Michael Cohen's lawyer, this Stephen Ryan, to release the name of his client, Sean Hannity. And Sean Hannity denies even being his client. It doesn't much matter. Moreover, the government lawyers in that courtroom are supposed to represent we, the people. And they should have objected and said, we're not asking for the release of his name. We don't believe his name should be released either, or her name. And then the slip and fall lawyer for CNN and the New York Times. The public has a right to know. The judge knows the public doesn't have a right to know. In other words, the government doesn't have the right to smear anybody, and neither does the judge. And neither do CNN and the New York Times. And look, they did exactly what the rule is intended to be in place to protect. To smear somebody. They did exactly that. Pretty damn incredible, don't you think? So Hannity's name is released in violation of the U.S. Attorney's Manual, in violation of judicial protocol. Yeah, Sean, you should have told everybody that you worked with the guy and you asked him some legal questions and so forth and so on. And yesterday and the day before, I went through all the conflicts and all the lies and all the hypocrisy of the media, all the frauds that they are. So don't hand me, hey, you should have announced it, like you're supposed to sit there every time something comes. You know what? I think I asked that guy a question or 3 or 5. I don't know. But I want you to know. Oh, wow, that clears up everything. Some of us believe that attorney-client privilege means something. Some of us are very concerned about what's going on in this courtroom with Kimball Woods. Doesn't matter if this guy was our lawyer or not. Of course, he wasn't mine, but you understand the point. The defense of attorney-client privilege, and there is an exception, there's the crime-fraud exception, but the defense of it is important for you. The failure of this judge and the government lawyers in the Southern District of New York to protect Sean Hannity's name, as they are to protect any innocent person's name in a criminal case, is an abomination. Is an abomination. While you have these clowns, these screwballs on CNN and MSNBC wringing their hands, so excited about the abuse of power in the courtroom, so excited about the abuse by prosecutors, so excited by a nitwit judge. Now, how many of them have consulted lawyers? Does attorney-client privilege apply to them? We have a right to know, they say. Now, you and I don't have a right to know anything, right? You and I don't have a right to know anything. When they have their sources, they say, no. We have our sources. You have a lawyer? Well, we have a right to know. So what was done to Hannity was an abuse of power and an abuse of justice by the United States Attorney's Office in the Southern District of New York and by a federal judge, the love judge by the name of Kimball Woods. It was an abuse of power. And CNN and the New York Times, through their lawyer, encouraged the court and the U.S. Attorney's Office to violate well-understood traditional rules in order to get Hannity. They wanted Hannity. Now you know the whole damn story. I'll be right back.
Mark Levin.